Read here, the Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh there, give their attention, for the court is now sitting. The United States of the United States, the State of Michigan, and this honorable court.
Welcome to the final argument of our November call. Final arguments, I should say. Number 4, Ronnisch versus Lofts. Is that you? Okay, now's the time.
Good afternoon. My name is Ron Cornell, and I represent Lofts on the 9. I would like to reserve 5 minutes of my allotted time for rebuttal.
You have to manage your own time here.
By allowing the Court of Appeals decision in this case to stand, the Court of Appeals has now effectively rewritten Section 118, subsection 2 of the Michigan Construction Lien Act to allow for the recovery of attorney's fees for breach of contract actions. Instead of actually needing to prevail on a lien foreclosure action to make a claim for attorney's fees under the Act, now all the parties need to do is to assert a lien foreclosure claim in a complaint with the breach of contract claim, and then file a motion for attorney's fees after litigating and arbitrating the breach of contract claim. No matter how liberal you construe the Act, that is not what Section 118.2 says. The Court of Appeals decision in this case should be reversed because it violates the plain language of the statute and this court's holding in Smith versus DeCina. Now, we all agree that Ronnisch is not entitled to attorney's fees under the construction contract for arbitrating its breach of contract claim. However, Section 118, Subpart 2 of the Lien Act does not give Ronnisch a right to attorney's fees either by simply asserting a lien foreclosure action in its breach of contract claim. Section 118, subsection 2 of the Lien Act expressly limits the recovery of attorney's fees to an action in which enforcement of a claim or construction lien is sought through foreclosure, not asserted, sought. The court then needs to examine the claims and defenses of the parties. The court then needs to determine the amount due each lien claimant. The court then needs to determine the priority of the lien claimants. And then finally, the court needs to determine who is the prevailing party. After going through all of that adjudication, then and only then is the trial court allowed to exercise some discretion to determine whether to award attorney's fees to the prevailing party. Well, those 5 things I just ticked off never occurred in our case. In our case, Ronnisch filed its suit for breach of contract and for foreclosure of its lien. The case was stayed. My client opposed, Lofts opposed the claim for balance of the construction contract of $626,000. We also opposed the time price differential claim they were making for another $173,000 in interest. The parties arbitrated. The arbitrator awarded Ronnisch $450,000 of its $800,000 contract claim, and then my client paid the full amount of the claim with interest and within 21 days of the award being entered. Then Ronnisch moved for a recovery of its attorney's fees by way of a motion. The trial court properly denied the motion. The Court of Appeals erred when it reversed. The Court of Appeals erred because it didn't follow the dictate of this court in Smith versus DeCina that said that this section of the Act does not permit recovery of attorney's fees for a contract action merely because it's brought with a lien foreclosure action. And then the Court of Appeals went on further and improperly analogized our case to Bosch and Solution Source. The big difference in those cases and ours is in those cases, the trial court actually adjudicated the lien foreclosure claim brought by the plaintiffs in those cases. That didn't happen here. Nor do we have in our case discovery sanctions leading to a default judgment, appeals, garnishments, dragging out payment for 4 years. We don't have an attempt to tender payment on the eve or on the day of the foreclosure action trial. Instead of analyzing this case as under Bosch and Solution Source, this court, the Court of Appeals, should have followed the plain dictates of the Act and this court's statements in Decina. In fact, there's one case we cited in our brief where another panel of the Court of Appeals seemed to get it right. That's the JL Construction case. It's an unpublished opinion. Nevertheless, you had the same circumstances here. Parties arbitrated a contract claim. After the arbitration award was entered, the contractor did not pay. Then, the subcontractor moved to enforce its construction lien, but it wanted to recover the attorney's fees and costs it had incurred in litigating the underlying breach of contract claim. The trial court denied the motion and clearly stated that while the statute allows for recovery of attorney's fees, it does not allow for them to be recovered in the underlying breach of contract action, only when a foreclosure claim is sought and adjudicated. In conclusion, Section 118,
Counsel, good
subpart...
afternoon. A question for you. What should the plaintiff have done differently here? I mean, this was the arbitrator that didn't reach a finding, so what is it that the plaintiff should have done differently?
If the plaintiff wanted to seek recovery of its attorney's fees and costs under the Lien Act, it would have done so by moving for summary disposition of its lien foreclosure claim in the underlying trial court matter. I would submit to you that it then and only then would then the right under Section 118 trigger to allow for the recovery of fees, but they would only be for the fees and costs incurred in the foreclosure proceedings, not the underlying breach of contract claim. If they wanted to recover their legal fees for litigating the breach of contract claim, well, then they should have negotiated that in the contract, the construction contract, and allocated the fees or had a fee-shifting provision in the construction contract. That didn't exist here.
Anything else?
Counsel, what does each claim in defense mean in the statute, 118, 1118, section 2?
Because that section appears in the middle of Section 118, subpart 2.
I mean, does that relate only to the lien foreclosure claim?
I would
Or does
submit
that
that
relate to other claims and defenses raised in the action as well?
Your Honor, I would submit that it relates to the lien foreclosure claim because the first premise of the first part of that sentence, the paragraph says, in each action which enforcement of a construction lien through foreclosure is sought.
But an action can involve more than one claim, right? And the language, each claim, seems to relate to some, I mean, wouldn't it just say, in an action to enforce a construction lien through foreclosure, the court shall examine that claim?
Well, Your Honor, I think that if you read it within the context of the entire section, where the allocation of reasonable attorney's fees is only allowed to the lien claimant, who is the prevailing party, to me, that claim that you're looking at, or the court should be looking at in defenses, are the claims related to that foreclosure action piece of the case, not the underlying breach of contract case.
Isn't the foreclosure action related to the underlying contract?
Both the underlying contract claim.
I mean, in other words, if someone didn't pay on a contract, or if they paid on the contract, there would be no foreclosure claim, right? If there has to be a relationship there that gives rise to the right to a lien, doesn't there?
Your Honor, yes, they are related. However, the act is distinct, and I think it's so what Section 117 allows a lien claimant to also bring a contract action with its lien foreclosure action, but it distinguishes the two, like the court in JLH Construction did. They distinguished the two. It said, you can have...
Excuse me, isn't this Justice Kavanaugh's position in Decina?
Pardon me, Your Honor.
That each claim, because, are you familiar with Justice Kavanaugh's decision?
Yes, Your Honor.
I think that's the same position that Justice Kavanaugh took, that because in each action which the enforcement is sought, the court shall examine each claim and defense that is presented and determine the amount of any. Each claim must include more than just the lien claim, and he goes on. That was his rationale for dissenting.
In the dissent, that's correct, Your Honor.
So my learned former colleague did bring up that issue in his dissent in the Decina case, but I have a sort of a follow-up question to what the Chief just said. in looking at Decina, in the order, in the majority portion of the order, there's a focus on the fact that the subcontractors lost on their lien claim. And when I look at the Construction Lien Act more broadly, as I've been taught to do, in particular some of the definitions, it defines lien claimant to mean a person having a right to a construction lien under this act. Now, once the lien claim has been adjudicated and the court determines, as it did in Decina, that the lien's not valid, it seems to me we can fairly conclude that that person is no longer a lien claimant, which is important because the attorney fee provision says that a lien claimant who prevails is entitled to fees. So couldn't I just read Decina to mean that once the claim has been adjudicated, that's when someone is no longer entitled to attorney fees? I know I'm giving a bit of a speech here, but let me go a little further. It seems to me there's three different positions we could take. We could take the position on the one extreme that once it's been adjudicated, like in Decina, there's no longer a right to a claim. We could take the position I think that you're urging on the other opposite side, that there has to be a judgment of foreclosure. Or there's an intermediate position that the Court of Appeals seems to have taken that's a little bit different than Decina, which is if you have what appears to be a valid claim that has not been adjudicated, but it appears to be valid. Your client, you went through an arbitration where, for the most part, a judgment was entered based on the arbitration award against your client. So it's if your client decided not to pay, most likely it seems to me, the other party would have been entitled to a judgment of foreclosure on their lien. So you see the three different positions, I guess.
I understand.
Why isn't the middle approach that the Court of Appeals took different than what happened in Decina and not the right outcome here?
Well, I think there's 2 points that I heard that I want to address. The first point is, in the underlying Decina case, they actually determined that the subcontractors had valid liens. However, they did not attach. Because the homeowner presented the affidavit, they had paid the general contractor. So there was that adjudication. But the distinction here, and why the Court of Appeals got it wrong, I believe, is because there was nothing ever done with respect to the lien in this case. Absolutely nothing.
Well, they filed the action, right?
That's all they did, was assert the claim. It's in the complaint. That's it.
But you know,
That's all they did.
I was a circuit judge once, and what happens in these cases is the parties come in and they say, we want to arbitrate. And then, of course, foreclosure is equitable, so the arbitrator doesn't have that power. And so it seems to me what happened in this case is exactly what happens. The case is stayed, or somehow the court retains jurisdiction to enforce the lien if that becomes necessary. Is that what happened here?
Yes, Your Honor, and that's exactly how the panel in the JLH Construction versus Fairview matter, the unpublished decision, handled it exactly like that. There was an underlying arbitration for the breach of contract claim. After that award was entered and the party didn't pay the award, we didn't do that here. We paid. We paid in full. We paid right away. Then the contractor moved to foreclose its construction lien, and in doing so, asked the trial court to not only award it legal fees for foreclosing the lien, but also all the legal fees incurred in the underlying breach of contract claim. And the court said, no, that's not how the Lien Act works. You have a separate and distinct contract claim. You litigate that contract claim. As Justice Bernstein pointed out, if they wanted to recover their attorney's fees, they could have written it into the contract between my client and had that fee shifting bargained for. That didn't happen here. The Lien Act is clear, in my opinion, that it's only when the action is to enforce the lien, when that starts, then the attorney's fee switch turns on. And after the court goes through all those steps to adjudicate the lien, to adjudicate the claims and defenses of other lien claimants, to establish priorities, those are the legal fees the Lien Act was supposed to protect the subcontractor and the contractor from, not the legal fees incurred in fighting the underlying breach of contract claim.
Can there be a lien foreclosure action without a breach of contract?
Absolutely. That's what the Lien Act says. The Lien Act does not require the contractor to bring an underlying breach of contract claim with its lien foreclosure claim. It allows it to happen, but it doesn't require it.
How would the court adjudicate the lien claim if there was no contract claim. There was no claim that one party didn't pay under a contract. What would the parties fight about
Well,
in that
they-
situation?
Well, they could fight about a variety of things. They could, if assuming there's a dispute on the amount owed, then the amount of the lien could be in dispute, whether the lien is
Isn't that a
excessive.
contractual issue? What the parties agreed to on the
It
amount?
might require the court to analyze the underlying contract and determine whether the amount stated by the lien claimant is accurate or whether it's overstated by including things it shouldn't include. It could also look at the timeliness of the lien, whether it was filed within the 90 days. It could look under, in some of these cases I've noticed, whether the owner paid the general contractor for the subcontractor's work. There's a variety of things that the court could undertake if it was solely looking to adjudicate the lien foreclosure action. But here we never got there. We never got there, and that's why Judge Kumar made the right call here. She denied the
In your
motion.
experience, how often do these cases get to the ultimate judgment of foreclosure?
Very rarely do they get to, well, let me put it this way, very rarely do they get to the actual foreclosure actually taking place. I have seen them get to the judgment of foreclosure being entered as further leverage to get payment, or sometimes you do have a situation where the owner just can't pay and they have to do something, or you have a lender that steps in and says, okay, that's not gonna happen, we're not selling the property.
And so I'm clear on your position, as long as your client pays at any point before a judgment of foreclosure is entered, there's no attorney fees under the statute?
Without running too close to the line like it was in Solution Source, in that case, if the lien has not yet been discharged or satisfied, then there's a chance that my client could have been exposed for attorney's fees and costs. But not where that example is Solution Source. Solution Source is where they paid, right at the day of the foreclosure trial. And the court in that case decided that it hadn't been dismissed or discharged and went forward with it. Or actually, that might have been the Bosch case, I'm sorry.
Did that court reach the right result? I'm trying to understand what rule you are advocating for here. Is it any point before the judgment of foreclosure is entered? Is that when the claim is adjudicated, according to your theory?
The claim, I think as long as the lien claimant has sought to enforce its lien through the process and goes down that path, such as a motion, a trial schedule, and I think that then the switch goes on for the
Why?
fees.
Why would that be, is that an adjudication?
Not a final adjudication. I guess it's a continuing.
So your view is, if you start down the road to try and adjudicate a claim, as you put it, the attorney fee switch goes on?
Well,
Because if that's the case, they
no.
file a claim, and that's,
no,
that's a process down to adjudication?
No, I apologize. I did not, I wasn't thinking of the day before the gavel comes down in the middle of the trial and there's a tender of payment. Once that trial is started to adjudicate that thing, I
Why?
don't.
Why is that, why would
Why is
that?
that more important than filing the claim?
Yeah.
Because I think the court at that point has jurisdiction to
They have
decide.
jurisdiction the day the complaint for the lien was filed. I don't understand the coherence of your argument. Either something is, the statute says adjudication, either adjudication means initiating and pursuing, or it means something more than that, which is a definitive determination.
Well, Your Honor, I was trying to figure out a way to reconcile what the Court of Appeals did in Solution Source, and that was the way I was trying to reconcile it. But if I had to state the position clearly and unequivocally,
Well, why do we
then-
do that? That's what we're really trying to do
Well,
here, is
you're-
have a definitive, accurate, reasonable construction of the statute. So what would that be?
That would be that unless those issues that I ticked off in the very beginning, there was an action started to actually start to foreclose that lien through foreclosure, the court does its adjudication of the claims, the defenses, establishes the priorities, and enters that judgment, then yes. Only at that point in time is the lien claimant, after that, entitled to go back and ask the court to add to its lien the fees and costs incurred in that foreclosure
So
proceeding.
it requires the court or somebody to determine the validity of the claim.
Of the lien?
Yes.
Yes. That has to happen. That has to happen.
Okay,
If we adopt your rule in this case, why would any lien claimant agree to arbitrate? I mean, I'm assuming, if I follow your rule, that anytime somebody decides to arbitrate, they give up any claim of attorney fees.
No, no, I don't think you can require an advance in writing, a waiver of attorney's fees or a lien right. I think they can arbitrate the underlying breach of contract claim, but the subcontractor can't be required to waive his lien rights. If he's not paid at the end of that arbitration, he'd have the right to pursue his lien claim and pursue for foreclosure.
is it your position that an arbitrator cannot determine the factual predicate for the lien? You may not be able to effectuate the judgment on the lien, but they can arbitrate whether the lien was valid, right?
If it's submitted to arbitration, but that was not what happened here.
Well, explain that. The lien claim was never submitted for
No,
arbitration.
it was not submitted for arbitration, just the breach of contract.
So-
Underlying
if-
breach of contract claim. If the parties in the process of their arbitration agreement allowed the arbitrator to make those factual, then I
To
think that.
determine the lien's
Yeah,
validity?
I'm assuming they could make that factual, but that didn't happen here.
Okay.
Was there any question in this case whether the lien was both valid and properly attached? If those are different things?
The only thing that I believe was addressed by one of the courts was it was timely filed within 90 days of the last work. That's about it. I would say it's not valid and it didn't attach because it was overstated. I never got the chance to present that argument to the trial court because it never came up in
Was
any
that an
context.
issue that was decided against your client in the arbitration?
No, I don't believe it was. I think the arbitrator just decided what was the balance of the contract claim. They
So
wanted
you-
800,000, they got 450. I would have still had the right to argue in front of the trial court that you cannot file a lien for $626,000, ask for time price differential for another 173, and try to lien my client's property for $800,000.
So you think you could have gone to the circuit judge and essentially relitigated what was decided by the arbitrator?
No, I'm not, the dollar amount is there, but the fact that it was overstated, well, I should have had the right to present that position, that the lien was not valid because it was overstated. The trial court would have to make that determination.
So you would ask the trial court to determine essentially that the damages that the other side was awarded, and there was an offset, I think, that's not the proper lien amount?
No, I think that the arbitration decided the lien amount. I'm saying that the claim of lien as filed, the 626, plus the time price differential of 173, is overstating the lien.
Does that make it invalid?
Yes. Prior case law that we've cited, that's an overstatement of the lien, it's not enforceable.
Wouldn't the trial court be bound by the amount that the arbitrator then, I mean, I don't disagree with you, if it's a larger amount and then the arbitrator comes up in his award or her award with a lower amount, isn't that the amount that the trial court would then use if there was a contest over, wasn't paid and they had to go forward on a lien foreclosure?
Sure, but I would still have the right to make my assertion that the lien was invalid. The lien timeliness, the amount, all of that we never got there.
I mean, I can understand it as it might relate to other items, timeliness and whether all the statutory prerequisites were adhered to, but I can't see amount. I don't understand how you get back into the amount. I thought that was the very issue the parties agreed to send to an arbitrator.
The arbitrator determined the amount, but the arbitrator didn't determine whether it was vexatious by them to lien up the property for 626 and that time price differential. I would make those arguments under the Scatetti case that it was vexatious and intentionally overstated.
So you
That
would
would the trial
argue under
court would have to
you would
do.
argue under the statute that your client was the prevailing party, even though you had to pay whatever the amount was?
I think I had the right to make that argument, absolutely. I was given that argument. The Court of Appeals took that away from the trial court and made it call on its own. I think that if you get $450,000 out of $800,000 claim and some of those amounts were improperly or dishonestly added to your lien claim, I certainly would have the right to stand in front of the trial court and argue they weren't the prevailing party. What would my client be forced to do in this situation? He'd be forced to pay the $800,000 because it couldn't dispute it and then sue to get the money back. That's the only other way I can avoid legal fees from triggering under this act.
Well, the fees are discretionary, are they not?
They are discretionary, but if I want to preserve the right to not have to have those fees take my client out of the risk of those fees, that's the only solution I have. I have to pay the full amount and then ask for it back. So they have no way of seeking recovery of attorney's fees and costs. Under the Court of Appeals decision in this case, that's what I'd have to do.
Do you wish to reserve any time?
Yes, 5 minutes, please.
You're got half a minute more than that if you want to waste those now.
No.
Good afternoon. May it please the court. My name is Mark Sasek. I'm attorney for Ronnisch Construction Group. This matter is about whether an unpaid contractor that prevailed in arbitration, which was part of an action to enforce a construction lien, should be entitled to seek an award for attorney fees and costs as the prevailing party. We respectfully submit that it should. We submit that the Court of Appeals, in its opinion, got this matter exactly right, and it should be affirmed. This matter is an issue of tremendous statewide importance. It involves two key issues that are common in construction disputes. One is the right of an unpaid contractor to the benefits of its lien and to the other benefits afforded to it under the Construction Lien Act. The second is the construction industry's frequent use of ADR as a dispute resolution mechanism. The Construction Lien Act has a specific directive in it that the statute is to be liberally construed to effectuate its purposes. That's under 570-13021. And there are two purposes under the Construction Lien Act. One is to make sure that owners don't have to pay twice. The second purpose is to ensure that unpaid contractors get paid and that they are able to seek their attorney fees and costs as a prevailing party. The contract in a construction case is inextricably intertwined with the construction lien. The Construction Lien Act recognizes this, that a party is entitled to a construction lien only if it makes an improvement pursuant to a contract. And a construction lien claimant is not entitled to a construction lien in excess of the payments actually made by the owner for that contract. In addition, the state has a policy that favors the arbitration of disputes. And the narrow reading that the appellant would ask this court to apply to this matter would both reward developers who wanted to hold money back and force contractors to undertake expensive legal proceedings, which is exactly the opposite of what the Construction Lien Act mandate is. And it would also discourage parties from attempting to use ADR as a dispute resolution mechanism. There's been a couple of representations to the court about the construction lien at issue here. The construction lien is for $626,000. The arbitrator awarded the full amount of that and then had an offset for some work that the arbitrator determined to be defective. And the net award to the contractor was $450,000. That award establishes the amount of the construction lien. And the trial court held, in the opinion denying our request to lift the stay and seek attorney fees, the trial court held that Ronnisch had perfected its construction lien and timely filed it, and there was an amount due. There was nothing vexatious about it. Ronnisch was the prevailing party. The case relied on by the appellant, the Decina case, is really not applicable to this matter. In Decina, you have I'm drawing the facts of Decina from the Court of Appeals opinion because the Supreme Court opinion didn't lay out the facts. But in Decina, you had an owner that paid the full amount of its contract. Therefore, the subcontractor that was claiming a lien was not entitled to have that lien attached to the property. That's entirely different than the situation that we have here. That deals with the first policy underlying the Construction Lien Act, that is, homeowners should not have to pay twice. Here we have a property owner that didn't pay hundreds of thousands of dollars to Ronnisch Construction. All the while, the property owner had the benefit of the constructed building and held the money. Under Decina, there's been some discussions about the action of foreclosure. Decina involved two actions, not one, as we have here. The subcontractor had one action against the Gobies, who were the homeowners, and a second action against the general contractor. They won on their action, or they prevailed on their action against the general contractor. They could not be a prevailing party against the homeowners because the homeowners had paid in full.
Could I just ask a question? This issue, how to construe what prevailing party meant, was the subject of a fairly extensive exchange, at least on the dissent's part, in Decina. And I realize Decina has some factual differences, yet the principle of Decina seems fairly straightforward. Justice, can you prevail unless Justice Kavanaugh's position is accepted in Decina?
Yes.
And tell me how that is.
Because in Decina, the lien claim by the subcontractor never attached to the owner's property. Therefore, they never could, the subcontractor in Decina could never invoke their other rights under the Construction Lien Act.
But everybody here agrees that there was no adjudication of the lien, right?
No, I don't agree with that.
All right, well, tell me in what way the arbitrator that reserved every issue relating to the lien adjudicated the Lien Act claim.
Well, one, I would submit that the adjudication of the contract amount is part of the action to adjudicate the lien, because there has to be...
That, I believe, is Justice Kavanaugh's view. Isn't that right?
No, because, well, if that was his view, and I don't think that's not the way I read it, then that would be mistaken.
I thought that many times, too.
In Decina, the subcontractor was owed money by the general contractor. Decina had a valid breach of contract claim against the general contractor, and Decina also had a claim under the Michigan Builders Trust Fund Act, because the general had been paid and it had trust funds that it had not paid to the subcontractor. But the homeowners in Decina had fully paid, so no liens could attach to the Gobies' property. And that's a critical distinction from Decina to our case. In our case, the trial court did hold that Ronnisch had perfected its lien. So there was the beginnings of an adjudication, or actually we went fairly far down the road, because the contract amount due had been adjudicated, and the trial court had held that Ronnisch's lien was perfected. But then the trial court made the mistake that brings us here, and the trial court decided that there was not an abuse of discretion. The trial court decided that it did not have any authority to adjudicate any further. And we submit that the Court of Appeals got it right by saying this matter should go back because you do have the authority, and whatever the trial court decides to hold as in terms of what attorney fees are appropriate, that would be the court's discretion.
Anything else?
The important point of this case, and the reason that it makes it so critical to the construction industry, is that construction contracts are fairly commonly using form contracts from various industry groups. The American Institute of Architects contract, the consensus documents put forward by the AGC, the Association of General Contractors, and others. And they all include one form or another of an arbitration provision, because it's understood in the construction industry that, one, courts don't like to see our construction cases because they involve huge amounts of paper. They take up huge amounts of resources of the court. They involve lots of witnesses and a lot of technical things. And arbitration is a very efficient and effective way of dealing with construction disputes. But if the court were to adopt the appellant's reasoning, no contractor would ever want to enter into an arbitration agreement. And that would frustrate the state's policy to encourage ADR. In addition—
Or they could negotiate to add liens in with the arbitration of the underlying contract.
They could do that, but they shouldn't have to, because under the Construction Lien Act, they already have that right. And Ronnisch never, when it entered into its contract, it never understood that that contract was waiving a right to attorney fees under the Lien Act.
There's no waiver. Why do you say that? The trial court, you said the trial court committed legal error in refusing to rule on the lien claim.
Correct.
I don't understand why that's a fault of the arbitration, or why people would not choose to enter into arbitrations if, as you say, the court abdicated its obligation to adjudicate a claim before it.
Right.
Okay, well, that's the error, not the fact that the parties agreed to arbitrate, isn't it?
Well, no, I agree with that. What I meant to say was that if the narrow interpretation of the Lien Act that the appellants seek is supported by this court, then it would be the effective abrogating
I'm
of—
not sure I understand how it's narrow to say you actually have to be, the lien claim actually has to be adjudicated by somebody. You think that's a narrow construction of this statute?
No.
Okay, well, that's what he's saying. You're
If-
just
if
saying.
that's what if
I
you
thought
heard,
you said, we had an entitlement to have an adjudication, we were robbed of it by the trial court.
We went far down the road in that adjudication. We filed a complaint for the adjudication.
But you didn't get an adjudication.
And then it was stopped. That is
Okay,
correct.
all right. Well, that's, I think what you're saying is the problem here, not that the construction of the statute is wrong, it's just we didn't get our adjudication that we were entitled to.
You're right. We are saying we didn't get the adjudication to which we're entitled, but the reason we didn't get that adjudication, I am arguing, is that the trial court misconstrued the statute. That's—
In what sense?
Because the trial court believed that because payment, even though Ronnisch had a timely filed claim of lien, and even though Ronnisch was owed $450,000 on that claim of lien, the 11th hour payment from the owner just prior to hearing on the motion to lift the stay and pursue attorney fees,
Right.
that negated Ronnisch's right to seek attorney fees.
I'm not sure I know clearly what the answer is, I think I know, but does payment of a lien discharge it?
Payment of a lien does
In full.
discharge, yes. And the court ordered us to discharge the lien. But it cannot be a liberal construction of the statute that requires a prevailing party to reject payment after having succeeded in the arbitration simply in the hopes that it might be awarded as reasonable attorney fees.
You're saying the court ordered the payment?
No, the court did not order the payment.
I
The
thought—
payment was voluntarily made.
Right, and
Yes.
accepted.
Yes. Yes, it was.
I'm having trouble then understanding why the trial court erred in saying there's no lien any further before me, goodbye.
Because the foreclosure action was already in place. Attorney fees under the lien are not a part of the actual lien. C.D. Barnes says that clearly, that the lien fee, that the attorney fees that the court has discretion to award are not part of the lien claim. It was advocated earlier that we would add that to the lien. You cannot add the attorney fees that you might be awarded to the lien claim. But the rights that Ronnisch has, the right that any lien claimant has when they are the prevailing party, includes the right to seek attorney fees. The statute doesn't say anything about having to withhold or to reject a tendered payment. And Bosch is very clear. In the case of Bosch, and I know it's a Court of Appeals case, and it's for your consideration. But Bosch, there was two separate actions. In Bosch, they had a contract action and a lien foreclosure action, and after having received a judgment in the contract action, they made their 11th hour tender, which is very similar to this. And in Bosch,
They were compelled to in
the
Bosch.
court, it's slightly different because the court did order that, but the principle's the same. You have a property owner that has been withholding money for, in this case, for over a year and a half, and using the property, using the work that the contractor did, and they're holding the money and using the property, and they make finally a payment after going through the entire arbitration, and it cannot be a liberal construction of the statute to say, oh, you don't have to take, you have to turn that down and hope that they don't use the money somewhere else or go into bankruptcy or have some other reason, and maybe you can get attorney fees depending on what the trial court holds.
Counsel, help me understand what you could have, if a majority of this court feels like the factual distinctions between this case and Decina don't allow us to bring it outside the Decina rule, what could you do next time to protect yourself? I'm just asking, like, what does a lawyer do if we say, sorry, the Decina rule is the Decina rule and it applies to these facts even though they are different?
Yes.
What would you do?
We would
What does
have
it
to
look like?
advise our clients to not enter into arbitrations, because it's wrong to say that the fees associated with the trial of the contract issues are not part of what can be sought from the whole foreclosure action. The statute says examine the claims and defenses, and that I submit includes all of the claims, including the contract claims. But if by taking the contract portion of those claims and putting them into arbitration, the contractor is no longer able to seek their attorney fees, then I would have to advise to my clients, don't do arbitrations.
The same thing, I think, could occur where there's no arbitration, because part of this is an equitable action. The trial court sort of maintains them both, but it usually has a jury to decide the legal issues and reserves on the equitable one. You could have the exact same situation replicated in the circuit court, that you get a tender of payment and the judge says, the lien has been discharged. I don't have to rule on it.
I agree that could happen, but that would be
Well, but I don't
error.
understand the difference then. You're saying that there's some magical divide that happens when you actually have the legal issue arbitrated as opposed to adjudicated in a circuit court. I think the same thing can happen.
Well, I don't think that we would be in a situation, the reason we were frustrated from being able to go forward with our seeking attorney fees is that the circuit court action was stayed pending the arbitration. And what we did is we made a motion to lift the stay. We couldn't make a motion for summary disposition. We had to lift the stay first.
Yeah.
And so when we sought to lift the stay,
You had already gotten a tender.
we had already had accepted it, and the court said, but see, if we were in...
That's a problem, but I don't see how that same scenario could happen in the circuit court.
But see, that's why Bosch would have held that wouldn't have it wouldn't have stopped us from being able to seek our attorney fees if we'd accepted that payment under the rule in Bosch, because that was a court proceeding.
Only because the court ordered the lien holder to take the payment.
It is a distinction, but I would submit that it's a distinction that doesn't matter with respect to the party's rights under the Construction Lien Act.
Okay.
If we apply the rule in Decina here, won't that mean that there will never be attorney fees for a lien claimant under the act unless a judgment of foreclosure is entered?
It does appear that Decina could be read that way. I think that Decina could be clarified, though, because it could be, this court could write an opinion that maintains Decina on the grounds that in Decina no lien attached, and therefore, because no lien attached, the contractor's other rights under the Lien Act were not triggered.
I mean, I don't disagree with you, but we could also interpret Decina to mean that you have to win on your foreclosure claim, prevail on your foreclosure claim to get attorney fees.
You
And
could,
if we
and
read-
I
if we
think that
read it-
would be a narrow interpretation of the Lien Act that would frustrate the purposes of getting contractors paid and getting their attorney fees. I mean, you certainly could do that.
In your experience, how often are judgments of foreclosures entered in lien actions?
Very rarely, and the judgment, very rarely is a judgment of foreclosure entered. There's frequently a partial summary disposition, usually on the contract claims, and at that point, the parties will
Settle.
make things happen.
Yeah,
Because
once-
usually
Once the amounts are established,
once the amounts are
the
established.
contract claim that's always attached to these cases, because you really couldn't litigate a lien foreclosure case if you didn't
Right.
resolve the amount that's owed, right? You never
Right.
could do that.
As in this case, it's very rare that a $6 million building would go to foreclosure when $450,000 is owed on it. And that's common with construction cases, because what ends up happening in construction cases is that the developer will look at it at the end and say, I just don't feel like paying that last application for payment, and I'm gonna have a basket of claims, and in this case, there was $1.5 million in counterclaims that they made, vast majority of which were rejected by the arbitrator, and that is a common thing that happens at the end of contract disputes. Now, the Lien Act has protections for wrongdoing contractors who attempt to overbill and such. That's why it's got the sworn statement requirement. That's why it's got the requirement that the lien not exceed the amount paid by the owner and other things. It also has that attorney fee provision to help contractors when they don't get paid. And it's important that that right be preserved. And in a liberal construction of the statute, contractors need to be able to seek their attorney fees.
It's also true that there's the provision immediately following one we're discussing now would allow your opposing side to obtain attorney fees if the court did indeed agree that what you are doing is vexatious, right?
It could happen. I think that would be wrong, but
In
I
this
mean,
case-
as a theoretical matter, yes.
Yeah, I'm talking generally, I'm not describing,
They could make the argument.
although counsel did, but I'm not describing those motives.
Thank you.
Thank you.
Do you have anything further?
I just want to address two very quick points. The first is that I may have been a misstatement, an accident by Mr. Sassick, but we did in fact pay the award within the 21 days. It was voluntarily accepted before they took any further action in the case whatsoever. We paid, they accepted, then they filed a motion to lift and for attorney's fees. So there wasn't a situation where we paid at the 11th hour as they claim. We paid within 21 days after the arbitration award came out.
According to your theory, once you pay, attorney fees are off the table, right?
For the most part, they should be, yes. But once we've satisfied that obligation.
Or once you offer to pay, I should say.
Well, we have to pay what's due, what's owed, absolutely. The other point I want
Only
to,
payment actually discharges a lien, right?
it should, yes.
An offer to pay doesn't
No,
discharge.
right, exactly, they have, right.
Okay.
Full
So is
payment.
it when they accepted payment?
They accepted here.
I mean,
yes.
but is that, I'm trying to figure out what the critical time was when their right or to at least seek attorney fees was extinguished,
When they accepted payment.
when they accepted payment.
Anything else? Thank you very much. Case is submitted. November call is concluded.